Open the meeting. Please call a roll to establish a quorum.
Mr. Bunkfest.
Present.
Dr. Keene.
Present.
Mr. Clarino.
Present.
Mr. Plummer.
Present.
Mr. Bowler.
Present.
We have a quorum.
You've had a chance to review the minutes. If there are any questions about that, if not, I'll entertain a motion to approve the minutes of the March 12th meeting.
Make a motion to approve the minutes of March 12th meeting as presented.
I'll
Motion
second
made.
that.
Who did the second?
I did.
Jeff did the second, okay. We'll just do this by voice vote. All in favor of approving the minutes, please signify by saying aye.
Aye.
Minutes stand approved. Staff, please review the rules and procedures for this meeting.
Yes, for all petitions, tonight's meeting has the following structure. The department will summarize the petition and describe what action, if any, is necessary to be taken. Then the petitioner will be given up to 15 minutes to present to the board. The president will open a public hearing. Individuals will be given 3 minutes to speak. Those representing a group will be given 5 minutes to speak. Only one member of the group will be given 5 minutes to speak. For efficiency purposes, we ask that those representing a group speak first. Public hearing will be closed when all interested members of the audience have had a chance to be heard and all emails received during the petition have been provided to board members. The petitioner will then have a chance to respond to comments, and the board will follow with any comments, questions, or concerns regarding the petition. As one word of note, the first item of tonight's business, the public hearing has already occurred, so that won't be in effect for the first item. Please do not disrupt the proceedings in any way. If you need to have a private discussion, we ask that you please quietly exit the room. Please silence your devices at this time, and if you must answer them, then please quietly exit the room. If you are attending in person and wish to speak in regards to a petition that has a scheduled public hearing, once the public hearing is opened by the president, please approach the podium and write your name and address in the sign-in sheet next to Kevin. If you are not attending in person, comments regarding a petition should be emailed to planners@westfield.in.gov with the petition name or number included in the subject line, and those comments will be forwarded to board members and the petitioner. During your comments, please state your name and address into the microphone for the record. We ask that you not repeat previously stated comments. Your presentation will be timed, and you'll be advised when there's approximately 30 seconds remaining. We'd also like to remind everyone to please speak directly into the microphone so your comments can be put onto the record. Thank you.
Thank you very much. We'll move on to the agenda. There's no change to the agenda, so the first item is a continued item from last meeting, 1255 West 161st Street. It's a variance to modify minimum lot area. And who's handling it? Weston's here, okay.
Yep. So thank you, President, members of the board. For the record, Weston Rogers with the Community Development Department. The item before you this evening is the continuance of a variance of development standard request for 1255 West 161st Street within the Agriculture Single-Family Rural Zoning District. The petitioner is here this evening requesting variance of development standard to reduce the minimum lot area and reduce the minimum lot frontage for the development of 3 residential lots on 4.41 acres. In addition, as part of this proposal, the petitioner is requesting to encroach into the minimum front yard building setback line along 161st Street due to future right-of-way dedication. To provide some context, this item was initially in front of the board at its March 12th meeting. The item was continued to this evening's meeting in order to review remonstrance and to provide clarity to the BZA on questions raised at the previous meeting. Staff has received 2 public comments since the public hearing was held. These comments were shared with the board in the handout that you received. In addition, the petitioner has provided an updated site plan, which was provided to you at the meeting today. The updated site plan still includes 3 lots. It just shows the proposed home location, which was also requested by the BZA at the previous meeting. The petitioner, Russell Brown of Clark Quinn Law, is here tonight and plans on making a brief presentation. Both the community development staff members and the public works staff members are available for questions should there be any. So this evening we have our stormwater manager coordinator and we have our city engineer with us as well, available for questions. So with that wraps up the brief introduction for this item. And if the petitioner would like to come forward and provide a presentation, welcome to it this time. Thank you.
Lot size exhibit, so the top 3. It's just to be flipped.
Good evening. For the record, I'm Russell Brown, an attorney with the law firm of Clark Quinn, 320 North Meridian Street, Suite 1100 in Indianapolis. I'll start and apologize that you got only via paper copy the site plan showing the building envelopes, that came late, that came over the weekend. And so it was a request, I believe, of previous, during the previous meeting. And we also were requested at the last meeting to consider moving the location of the drive from the newly formed lot that has frontage along 161st Street to the existing home lot. I did provide a site plan to that. However, our request would be that we go with the original site plan. And the reason for that request is that that revised location would require the removal of some existing trees near to the existing home. So the drive, moving it onto that existing home side, we believe would actually have a negative effect on moving it to that location. I believe your request, the reason for your request previously was to determine where homes could be located, what size homes could be located on those new existing lots, and how they could comply with the existing zoning standards. Testimony that I gave last month indicated that there were not going to be any requests for modifications to side yard, rear yard setbacks, that we could comply with the front yard setback even with the revised dedication. We believe that site plan with those building envelopes shows just that. I also have on the screen one document I want to walk through very quickly. Part of the remonstrance and part of the issues raised last month was whether or not a subdivision of this property would be in alignment with what's nearby to it. And I will tell you that I think there's probably two disagreements between our position and the position of the remonstrators. First, what is immediate vicinity? The remonstrators have limited their testimony and their matters that are into the record to just the southeast quadrant of 161st and Ditch. So if it's not in that quadrant, they don't consider it to be the immediate vicinity. I think that's an inaccurate reflection of what you as a board under your statutory elements can or should consider. I think it's the immediate vicinity, which includes north, includes in all directions from the property. The other is there's an exhibit in the remonstrance documents which show the assembled property owned by under common land ownership. What I've done is I've went through GIS, through the assessor's records, and actually looked at the lot size that exists. So one owner may own multiple lots in the area, so they have an assembled area that is larger, in most respects, larger than perhaps what is proposed tonight. But what I've shown here is that anything in blue is a lot that exists, an existing legally established lot that is less than 1 acre in size. So every lot proposed tonight would be larger than these lots. What is in green is between 1 and 2 acres in size. And what is in red is 3 acres, between 2 and 3 acres in size. And these are 4 lots. Understand that there are owners who own multiple lots, so they have an aggregate ownership of 3 acres, 5 acres, 7 acres, but those lots exist, and I think that's an important context for when I talk about the area and the nearby area, that this is a request to create 2 lots of approximately 1 acre in size and a lot that's nearly 2 acres that's not out of context with what's nearby to it. I also bring to your attention those lots that are north of 161st Street. These 3 lots here are laid out almost very similarly to what we're proposing here, where you have 2 lots that have no direct frontage along 161st Street. So I wanted to point that out as context. It was raised a lot. I didn't have the opportunity to have an exhibit like this last month when we were here. The other thing that I would show is just the pond that's at issue in all of these matters. That's been a big issue in this matter. First of all, this is the open area that we're proposing to subdivide to build potentially build a new home at a later date. So you can see in the background there, you can see the pond itself. You can also see what's behind it to the south. The other picture that we would show is where the pond is today. Actually, this is yesterday, but where the pond is yesterday. We heard testimony that was given is that this is not part of the drainage infrastructure necessarily that the city has or the county has, but more is an aesthetic pond, but it does raise and lower over the year as rainfall occurs. As you'll notice, it is near or at its brim today. So the rain that's predicted for the rest of the week that will wipe out high school baseball, where I should be for the rest of the week, will not end up in this pond. It will move through, it will move on to adjacent property owners. So this pond, as it exists today, yesterday, is not adding or subtracting to the drainage infrastructure as it exists today. So our position is that the removal of that to allow for these additional developable lots will not have a negative impact on the use and enjoyment of adjacent properties because of the absence of this pond if and when it's removed. So with that, I believe we tried to address the questions of the board from last month and happy to answer if there are additional questions. But otherwise, we would request your favorable approval of these three variances that are before you this evening.
Any board members have questions of the petitioner?
Question for staff again, just as a reminder from our last meeting. Dane, we are solely approving obvious use today, and so I think while I appreciate engineering and public works being here, it's not necessarily in our purview to have that conversation. On that note, could you please remind us the steps from where we go today after we approve use, just so this board understands what's left on that kind of checklist?
Sure, so if the board is so inclined to approve the variance today, this would still require going through what's called a minor platting process. The plat itself would be drawn up by a surveyor. It would head to our technical advisory committee, which is reviewed. The committee is made up of utility companies, public works, fire, community development, things like that, and to ensure that the standards within the plat are compatible with all the applicable construction standards, all the applicable zoning standards and everything like that, which would include the variances granted if so chosen. And then the surveyor would then get signatures and from community development and public works and have the plat itself recorded at the county recorder's office to create the new tax parcels. And that would then be creating the new lots. So that would be all subsequent to any variances that were approved tonight if that happens.
And so in further extension, if for some reason after much due diligence and TAC meetings it is found that that pond or the drainage is not sufficient, they have the right to withhold all permitting and not move forward with the subdivision of this, is that correct?
Well, I'll leave that up to Michael Pierce to discuss, our city engineer, and how that review happens on the public works end.
Sure, and Michael Pierce, city engineer, for the record. Yeah, so part of our review process would be to look at the site, and we would have to ensure that the site would meet our drainage requirements, which is based on a release rate. So it's basically how much water is leaving the site. So one of the things that we would do with that was be ask them to basically provide a calculation of the water leaving the site to make sure that it meets our stormwater requirements and that it's not basically negatively impacting surrounding lots around there. So that would be part of our review as we go through the process of reviewing the property.
Have you looked at this at all?
Correct, yes, I have.
Now, have you
Yep.
looked at it?
Yep.
Including
Yeah,
the
correct.
proposed paved driveway?
Yes, I've seen a diagram of their proposed pavement on there.
Are you comfortable with the amount? I mean, there's a lot of runoff here.
Agreed, and so part of those calculations that I was mentioning is when they have a design that comes in here, what we would do, it kind of master plan this site for 3 lots, including the driveway, including the impervious area, That would include draining it in a proper manner so that it's collected and then it's not just discharged onto an adjacent site or just, discharged onto somebody's backyard. They would collect that. And typically, in a larger subdivision, you have a large pond that would collect it all together. In a situation like this, there's probably some other means that they could look at doing, whether that be oversizing, like, putting in a storm sewer line, oversizing it, doing an infiltration trench. There's just various ways that you can collect that and keep it from just direct discharging onto somebody else's property.
Have you looked at the amount of water that runs across this lot from the adjacent lots?
Yes, I have.
currently?
I've seen that it generally in this if you want to look at it as the southeast quadrant of 161st and I believe it's Ditch Road just to the west. That drainage pattern generally runs from about Ditch Road, runs east, going through that corner, and then eventually making its way ultimately into that pond that's just I believe it's on the west end of West Rail, kind of in that near the Trestle Drive. I believe that's what it is. That's kind of the ultimate drainage pattern, as it flows from west to east through that area. But as I said, I don't think that the existing pond that's there, as the petitioner kind of explained, that pond is not designed as a detention basin. So if you look at a typical detention basin, such as the one that's provided in West Rail, I try to think of it, simple analogy is kind of think of it as a bowl. So in a detention basin that's properly designed for the purposes of detention, you have a bowl that's about half full of water at its normal condition. The level between the top of the bowl and where the water usually sits, that's your actual volume of water. So that's collected when it rains in there. It's stored in there, and then that's slowly released through an outlet control structure, and then ultimately into like a legal drain or a ditch or something like that, so that it's collected in there, it's held in there, and then it's dispersed at a controlled rate. As we mentioned with this pond, based on the topography that I've seen through there, based on the aerial photos, this is basically a bowl that in normal conditions is usually pretty much just full. So the water goes in there and it's just passed through the normal drainage pattern of the site.
So let me make sure I'm clear with this. So the petitioner, by coming forward to develop these properties, is now going to have to assume the cost of improving the drainage so that it has to go into sewer receptacle or water receptacle someplace, so that he's going to have to mitigate the drainage issues that are there now.
He would have to mitigate, he'd have to find a proper outlet for his water that is not negatively impacting other properties.
And the developer is the one that bears the cost of that.
Correct.
And to the standards that DNA and you.
Correct, yeah, just like if like when West Rail came through, they were required to build ponds for their site, find an appropriate outlet, storm it into that, into an acceptable outlet from there. Obviously, that's a much larger scale. Something here is, much more minor, but it's the same concept.
Other questions?
For the petitioner, thank you very much. I don't know if we talked about this the last meeting. The tree line that is to the east of the property, is that on your property or your neighbor's property? Essentially, yes, that right there.
We're not sure. I don't believe it's on the petitioner's property, but we don't believe it is, but I can't say that with 100% certainty.
Okay. And understanding your motion for leaving the drive as shown in your initial plan would be for tree preservation, so there'd be some level of commitment upon observation that if any trees do fall on that property, those would be maintained accordingly?
Yeah, that's an obligation of the ordinance, yes.
Thank you.
Are there any further questions from any of the members? If not, I'll entertain a motion on this item.
I think you need a public hearing, don't you?
We had the public hearing last month.
Understanding that this body's sole purpose is to approve use, and there are several regulatory hurdles still in front of the petitioner, I make a motion to approve 2403 VS 08.
We have a motion for approval. Is there a second? Not hearing a second, I will entertain another motion on this item. Chair is recognizing a little reluctance on the part of the BZA members to do something. Is there someplace we want to go with this?
If I may step in as legal counsel, it's usually a general format to make a motion in a positive situation. A second doesn't mean you necessarily have to approve or deny the petition, but usually a motion is made to either approve, deny, or approve or deny in this case with regard to BZA votes.
So his motion, we can act upon the motion without a second?
If, without a second, no, it died.
Nice, okay.
So something has to, I mean, you can't just let it sit here. There has to be a motion.
The meeting will end at some point in time.
Correct.
Are there further questions we might have of staff or further investigations that we would want, or we would want? I hate to drag people back again, but I want to make sure that everybody's comfortable with what action we're going to take. Are there other things we want to see the staff do in this regard?
I don't know that there's much that staff can do at this point. This is a petitioner-led item. If you have requests of the petitioner that you'd be amenable to seeing modified in regards to the site plan, really it's the petitioner that you need to ask questions about what you like or don't like at this point.
So I guess one question would be, what's the resolution of all of the comments that were received from the adjacent properties? Has that been addressed?
Wes, you want to, I mean, I don't know that I understand the question. There are comments provided at the last public hearing, and there's a staff report that outlines what comments were given and, you know, it's up to the board on whether or not they want to take those comments into consideration, and based on the findings of fact of the staff report, if they agree or disagree with the findings, then vote accordingly. It's also, the board also has the opportunity to ask the petitioner to, if they would be amenable to modifying the plan in an agreeable way that would make the board feel comfortable voting on something. It doesn't inherently have to be this exact request, but that question has not been answered or asked yet.
I guess explaining as to why I made a motion, let's start there. Again, I believe this body's purpose is to approve developmental standards and developmental variance uses. So in this categorization, I think what we are considering today is solely the use of 2 additional parcels contiguous to this homeowner. A lot of the public comment, for very obvious and very reasonable reasons, have very heavy concerns on drainage and overall utilities within the corridor, and several other things that this city has employed several highly astute individuals to examine through many regulatory processes. On that note, the reason I made the motion is I believe the use, albeit contrary to the surrounding homeowners, does conform with some of the surrounding developments. Now, I don't want to sit here and say I fully agree with the petitioner's comments of comparing new development of incredibly high density to a use like this, but I do see the merit of the approach.
Would you like to redo your motion to see if there's another second?
I'll make a motion to approve 2403 VS 08, the variance of development standards to 1255 West 161st Street.
I'll second that motion.
Okay, we have a motion and a second. Discussion from the members.
One thing that bothers me, and I'm the new guy here, so, one of the new guys. I don't think I have enough information on this. The initial drawing looked like it was done on the back of a napkin. We're talking about a pretty serious development here that's going to affect the entire neighborhood all around it. And our initial layout was, you know, I'm not sure I have enough information to approve this.
As a developer by day, I will comment, I believe information is often sought after initial approvals are received. And so I think before opportunity costs can be expended and much further review will again happen by staff, by the folks who make these decisions, they need to understand that the use is permissible.
Just a reminder to the board, I suppose, that the only items that the board is voting on this evening in regards to this petition is lot size and lot frontage. That is what you're voting on. Now, in a vacuum, this is the result of that, for certain, but those are technically the only two development standards. And well, and setback for the front yard. So three. But, so yes, as in a vacuum, it's those three things. Put into practice, it's this. So just keep in mind what you're voting on and how it would be applied, because this concept plan, I'm guessing, would require substantial compliance as it goes through the plating process. So you're voting on development standards, but also voting technically on this too.
Well, I'm going to make a comment on this. You know, we're into land use is what we're all about. There's a similar project across the street with the three houses back to back to back. I also would have some concerns about 3 or 4 of the larger lots being bought up and then it's a new subdivision put in, and development like this gives a little bit of diversity to a neighborhood. And the lots, I'm assuming that petitioner's picture graph with the colors was correct. The lot sizes are not that out of line with a lot of the individual lots around there. So there's a lot of good reasons to, from a property usage standpoint, to support the motion. Any other comments? Seeing none, then I would ask, call the roll on the motion.
Dr. Keen,
Yes?
Mr. Bowler,
Yes.
Mr. Clarino,
No.
Mr. Plummer,
Yes.
Mr. Bunkefest.
Yes.
Motion carries.
Thank you. On to the next item.
The findings of fact.
Oh, I'm sorry. No public hearing. I would entertain a motion on findings of fact on the 1255 West 161st Street item.
I'll make that motion.
Is there a second?
I'll second.
Motion and a second. Any comments? Please call the roll.
Dr. Keen,
Yes?
Mr. Bowler,
Yes.
Mr. Clarino,
Yes.
Mr. Plummer,
Yes.
Mr. Bunkefest.
Yes.
Motion carries.
Now, moving on, we have 3 items before us, all requiring a public hearing. The first one is 16717 Gaither Boulevard. Weston, you're up on this one.
Yep, thank you, President, members of the board. For the record, Weston Rogers with the Community Development Department. The property is located at 16717 Gaither Boulevard within the SF2 single-family low-density zoning district. The petitioner is here this evening to request a variance of development standard to encroach 15 feet into the 30-foot rear yard setback line. This item does require a public hearing tonight and has been properly noticed and advertised. Staff has received 1 public comment, which is made part of the agenda. To conclude this introduction, the petitioner is here tonight and plans to make a just very brief presentation, if you'd like, and both the petitioner and staff are available for questions should you have any. Thank you.
Good evening. I'm Bruce McLean with Pools of Fun, and I'm here on behalf of my client for the encroachment request.
Any questions of the petitioner? No questions.
Thanks.
This item does require a public hearing, so I will open the public hearing at 7:30. And just remind anybody listening in that you can email public comments. We'll wait for a chance to wait to see if we get any of those.
Bless you.
No comments? Email? Okay. Then I will close the hearing at 7:32. Comments from anybody on the board?
This looks similar to previous requests that we've had, so I don't have any further comments.
Is there a motion?
I'll make a motion to approve 2404-VS-14-16717 Gaither Boulevard.
I have a motion. Is there a second?
Okay, no, go ahead.
Second.
Okay, we have a motion and a second. Any comment, discussion? Not, please call the roll.
Mr. Bowler,
Yes.
Mr. Clarino,
Yes.
Mr. Plummer,
Yes.
Mr. Bunkefest,
Yes.
Dr. Keen.
Yes.
Motion carries.
Moving into findings of fact for this particular item, do I have a motion on findings of fact?
Make a motion to approve findings of fact for
Billy makes a motion.
2404 VS-14.
I have a motion, is there a second?
I'll second.
I have a motion and a second. Discussion? Call the roll.
Mr. Bowler,
Yes.
Mr. Clarino,
Yes.
Mr. Plummer,
Yes.
Mr. Bunkefest,
Yes.
Dr. Keen.
Yes.
Motion carries.
Moving on to the next item, which also requires a public hearing. 20915 Stewart Estate Lane, the variance of a development standard. And Dane, you are the one on this one.
If I could close all these tabs. All right, good evening, members of the board. For the record, Dane Crabtree with the Community Development Department. The item before you this evening is a proposed variance of development standard to encroach 16 feet into the 25.5-foot minimum rear yard setback to accommodate a cocktail pool and deck on .59 acres in the Chatham Hills PUD. This item has been publicly noticed and advertised. The department has received no public comments, and the proposal has been approved by the Chatham Hills Homeowners Association. The representative for the homeowner, PJE Lawn Care, is present this evening for questions. They don't plan to make a presentation, but are available if you have them.
Do we have any questions of the petitioner? Seeing none, then I will open the public hearing at 7:33. Received any comments? Comments? No comments, I will close the public hearing at 7:35. Entertain a motion on this particular item?
I'll make a motion that we approve item 2404 VA 15.
We have a motion to approve. Is there a second?
I'll second it.
We have a motion and a second. Any comments? Please call the roll.
Mr. Clarino.
Yes.
Mr. Plummer.
Yes.
Mr. Bunkafest.
Yes.
Dr. Keen.
Yes.
Mr. Bowler.
Yes.
Motion carries.
Motion is approved. We'll move on to findings of fact. Do I have a motion on findings of fact?
I'll make a motion.
We have a motion. Is there a second?
I'll second.
Any comments? No comments. Please call the roll on the findings of fact.
Mr. Clarino.
Yes.
Mr. Plummer.
Yes.
Mr. Bunkafest.
Yes.
Dr. Keen.
Yes.
Mr. Bowler.
Yes.
Motion carries.
And our last item requiring a public hearing, 16616 South Park Drive. Dane, you're on that one.
Yes, good evening, members of the board. For the record, Dane Crabtree with the Community Development Department. The item before you this evening is a proposed variance of use request for 4.2 acres of property in the South Park Business Park. Property on which the building is located is zoned enclosed industrial, while the ancillary parking lot technically zoned the South Oak PUD. The proposal is for a civic center with a religious institution component. As noted in the staff report, there are recommended conditions in the event that the BZA is inclined to grant the variance, which the petitioner has agreed to. These conditions are such that the variance would be tied to the petitioner. The variance is tied to the petitioner's statement of intent. The variance is contingent upon a payment in lieu of taxes agreement with the city. A new variance would be required if there is any major building footprint expansion on the property, and no loudspeakers or similar devices be incorporated external to the building in conjunction with the variance. This item has been properly noticed and advertised. The department has received one public comment, which was provided to you this evening. The representative on behalf of the petitioner, Eric Dowsett with Church Hill and Antrim, is present this evening to make a brief presentation, after which he will be available for questions as well as staff. Thank you.
Thank you, Dane. Eric Douthit, Church Hill and Antrim, 116th North Union here in Westfield. Pleased today to be here to represent the petitioner and applicant in this particular item. I'll try not to repeat anything Dane has said, but just add some supplemental information to it. This is a not-for-profit. Typically, not-for-profits aren't required to pay any property taxes. In this particular instance, the city and the user have agreed to what's called a payment in lieu of taxes agreement. That payment in lieu of taxes agreement has already been approved by the RDC, subject to your approval tonight. This particular use and that pilot are tied to this particular applicant. So if there's a transfer either with or without consideration to any third party, including an affiliate of the applicant, both that pilot and that use would terminate. An additional amendment, variance, or PUD would have to come before the appropriate board in order for that variance to go into effect. This variance is for use only. There are no modifications with regards to the building that are anticipated at this time of significance. Within the document, you'll see that if there is any change of significance within the building footprint, that would need to come back before you again for purposes of variance or through an appropriate another administrative board. Even though this was a BZA, we did have a neighbor meeting for this particular use in order to A, get to meet the neighbors, and B, answer any of the questions they've had. One of the neighbors is here tonight, the neighbor to our direct north, the owner of Round Trippers. That meeting went well. We got some feedback specifically with regard to the question of the use of the loudspeakers. The religious component of this would be for Friday prayers, and it is typical in the Muslim faith that there can be a call to prayer. That won't be the case here. It's all internal, so there are no external loudspeakers with this at all, and we've made a commitment to that effect as well. There were also questions with regards to the parking. We believe that's handled within one of the commitments we've made with regards to the size of any use that's out there. And as a side note, there's also within the covenants and restrictions requirement that there's no on-street parking. Everything has to be parked on the facility, and that is the intent of our client. I'm happy to answer any other specific questions you have about this. We would encourage the board to accept the findings of facts and the conclusions of law as proposed, and look forward to answering any questions you may have.
Thank you. Any questions of the petitioner?
Could you explain just a little bit more about the payment in lieu?
Certainly.
Is that, what is it? how's it calculated?
Certainly. So in this particular circumstance, the payment in lieu of taxes agreement is that the user will pay the city component of what the property taxes would be if it were subject to property taxes. Since there are no, this isn't a residence, there's going to be no direct impact on the schools, library, township, or county. So we've agreed to pay exactly what would be owed for the schools for maintenance of the roads and other infrastructure within the city. In the event that the assessed value were to go up or the city property tax rate would go up, this rate would float directly in line with what would otherwise be owed on your property tax bill for the city component. As you may or may not know, there are 5 components within your bill: city, county, schools, library, and township. So this would only pay the city component to help with the city infrastructure cost that would be associated with this. That's especially important because this is generally a commercial zone. We want to make sure that the city got its property taxes for that commercial zone, and this use will be using those city resources.
The hospital here has the same agreement.
Yeah.
So,
Okay.
other questions, petitioner? Not this requires a public hearing. I will open a public hearing on this item is 16616 South Park Drive at 7:41. Any comments, Dane? No comments? I will close the hearing at 7:43. Any comments or motion for this item?
I'll just have a quick clarification question for staff. So obviously, we mentioned they had acquired some additional property contiguous to this for parking. That exact matrix will be determined by you through additional coordination, correct?
So the parking lot that is south of this has already been in place, and so they're planning on using that parking lot as it exists today, and my understanding is they plan to repave it, but not expand it at this time. This use would still be subject to all the existing parking and loading standards of the UDO, so if by some chance that they were not parking in accordance with those standards, this would be subject to code enforcement, or in the event that they wanted to expand the parking lot, they would have an opportunity to do that at a future date as well. So.
Thank you.
Would it make more sense to, I think the wording is subject to major footprint modifications. Would it be make more sense just to take that out and for clarification, and just any change in footprint would require coming back?
No, I don't believe so, because if they were to, for example, expand into a single room of a 10 by 20 room or something like that, it would not be major enough to warrant consideration of the board to continue the variance again. So that's why we left it up to the director's discretion on what major is, so that way, if it is before you again, it's because the director feels like further consideration is warranted because the use has intensified in such a way.
Okay.
In addition of a 200 square foot classroom or something like that would not necessarily do that.
Makes sense.
Yeah.
Entertain a motion?
I can make a motion to approve 2404 VU 06.
We have a motion, is there a second?
I'll second.
Okay, we have a second. Any discussion? Now please call the roll.
Mr. Plummer,
Yes.
Mr. Bunkefest,
Yes.
Dr. Keen,
Yes.
Mr. Bowler,
Yes.
Mr. Clarino,
Yes.
motion carries.
For the item, now we'll move to the findings of fact. Do we have a motion on findings of fact?
I'll make a motion.
Motion by Jeff, second?
Second.
We have a second. No comments, I assume, so we'll go to call the roll, please.
Mr. Plummer,
Yes.
Mr. Mr. Bunkefast.
Yes.
Dr. Keen.
Yes,
Mr. Buller.
Yes.
Mr. Clarino.
Yes.
Motion carries.
thank you very much.
Thank you.
No items continued to a future meeting, so we will go to reports. Plan Commission Liaison, which is me. I'll just talk about, we had a couple of PUDs that were approved out along 193rd Street, no, 193rd Street and Eagletown Road. I think the biggest one was another was the North Point 2 PUD, which was contentious a year ago. But I think staff members, mayor in particular, put his I would say, reputation at stake by getting right down, working with them and work with all the members of that area and came out with an agreement. And so they moved forward on the North Point 2 PUD. And then along Union, right by 171st Street, 169th Street, the town's Union PUD, really a nice townhome development. Pulte increased the size to about, I think, 3-story, 2,300 square foot unit minimum, very, very nice. And so that was approved too, and we'll begin somewhere down the road here. So that's a couple other things moved into our work session next week. Report that next month. Community development.
Yeah, I just wanted to make a quick announcement. We have hired another associate planner, Shelby Alexander. She starts, well, she's already started part-time with us, I think a week or two ago. She's finishing up her degree this spring, so when she graduates, she will start with us full-time, so you'll meet her then, later in May. But just wanted to make you aware that we've added headcount to our team, and Shelby will be working with you in the future. So when she gets here in person, we'll introduce her more formally, but wanted to give you that information. That's it from us.
Okay, we'll entertain a motion for adjournment.
Motion to adjourn.
A second?
Second.
Motion and a second, voice vote, all in favor say aye.
Aye.
Meeting is adjourned.